University, Professor Carlo Carraro, couldn't be here today. I would like to very warmly thank Professor Adrian Goldin to having accepted to come here for this very important afternoon in a very, very nice day, actually. It is important because it's the first seminar on labor, and all of you know that Ca' Foscari University choose to select labor as the main topic for this academic year, in order to put every effort both on the research side and on the service side, in the sense of orientation and placement of our students, looking at how the university may better serve the request of innovation in the labor market. And therefore it's very, very important to start this academic year on labor with a presence of a high-level personality like Professor Adrian Goldin, who is the president of the International Society of Labor and Social Security Law. And it's also important to have among us very, very distinguished people, not only from the university actually, for this afternoon that we'll see not only the presentation by the conference by Professor Goldin, but also the start of a new master course and the finish ceremony of the master on labor. It's you know, Professor Goldin, that Ca' Foscari is not a big university, it's a medium-sized university, but very active, and we have about 500 faculty members, 20,000 students. We are some topics that characterize the university with respect to other universities, and in particular what characterizes Ca' Foscari is the possibility to make economy, law science, foreign languages, and some hard sciences interact each other. And so it's very important that in this setting of a university which wants to be international and dynamics, that the scientific research start from understanding basic ideas, and having you speaking about the idea of labor law I think it's a good point as a foundational point. I would like also to warmly thank Professor Perulli, who is the very active promoter of all these initiatives at the University of Venice, and is also a delegate of our rector for all the matters that concern the placement and the interaction between the university and labor agencies. So thank you very much, Professor Perulli, and thank you very much, Professor Goldin, for being here.
I think you proceed with this very beautiful introduction.
Okay. Thank you very much. Thank you very much to the Università Ca' Foscari, Mr. Cortese, Mr. Perulli, for this reception. It's a pleasure for me, but mainly it's an honor. And thank you very much for being here. Support the stand, what I'm going to say now, which is not research. It's just an say, and it's in fact I've been working and looking for what I call some defining features of labor law. What's a structure, what's basic of labor law. I think that such a search is important in this very moment in which we have labor law in flux, considering that it is this moment and we should know what's changing, and if those defining features which change, also the changes are deeper and more important. A law, in this case labor law, if it changes in its defining features, it changes deeply, it changes a lot. And besides that, when we look for those defining features, in fact, we are looking for something that we professors are doing all the time long, that we are trying to find, to teach those keys for understanding labor law. And mainly these basic features, these defining features, are, as Alain Supiot said, he said that in French, les clés d'intelligibilité, the key for understanding labor law, and there's a coincidence between what's defining and what's a key of understanding. Well, just for methodological reasons, I'm just looking for some legal techniques and concepts. So I won't go for foundations, I won't go for functions. The function analysis is very important to understand labor law. I won't go even for contents. I won't speak about wages, I won't speak about working time, and not because it's not important, it's just a partial option to be able to say something. And so I'm just looking for these, I insist, legal techniques and legal concepts, which I think are the most intimate, the most basic components of labor law. So please understand that I don't intend to consider the newest, I don't intend to consider the most innovative, but instead what's more traditional and established. There we must waive any pretension of originality. There's nothing new in this, it's just more an effort to identify and recognize those features which I think are very, very important. It's to be said that these features, which are the most basic and structural of labor law, do not belong exclusively to labor law. In fact, they belong to some other branches of law. There's a conception in which labor law is considered an horizontal law. We go through the verticals law. An horizontal law is one of those laws which is referring to a certain kind of persons, in this case workers and employers. And there are some vertical law who are homogeneous constructions with some functions, like, say, civil law, administrative law, criminal law, international law, and this horizontal law go transversally through all those vertical laws and capture from them some institutions, and then it adapts to its necessities, to the needs of labor law. So, a first question that I have to pose, if these defining features of labor law have an universal conditions, if they belong to all the labor laws in the world. And I think they don't. I think we have just to apply that search to some special labor law, and I'll tell after. But when I started thinking about this question, it was when I started thinking about what it was called the idea of labor law. That was a seminar held in Cambridge, University of Cambridge, on the idea of labor law. And then I tried to think if there was something like a universal idea of labor law. That was my task in that meeting. And what I thought that if it was possible to recognize something like a universal, basic historical idea of labor law, it should be posed in a very basic and stylized way, because if not, it's impossible to have that kind of generality. And that conceptual search started recognizing that work wasn't a human experience, neither free nor voluntary experiences. Human work was, in most cases, manifested in non-voluntary relationships. Remember, of course, slavery, the feudal vassalage, serfdom, the membership in guilds, corporations. There was not freedom in that. And it could be said that labor law started as labor law when it appeared the contract as a luminous manifestation of freedom. So, in my opinion, labor law starts with contract, with freedom in relation to a situation in which freedom was not an element of labor relations, at least in its historical perspective. It's kind of curious for labor lawyers to speak about labor contract, the contract of employment, as a manifestation of freedom. We don't think that, we have doubts on that. And what happens, it's necessary to accept that contract as freedom has been possible because within that contract it was the way of disciplining workers. It was the way of subjection. And then that labor contract is an indissoluble mix between contract as freedom and contract as subjection. I think this is a basic idea of labor law. Labor law leads with a contract which has in itself a mix between contract as freedom and contract as subjection. Subjection, of course, in the figure of dependence, of which we will speak a little bit later. So, if I should start giving kind of a concept of a basic historical and quasi-universal idea of labor law, I say that it starts with contract, with that mix between contract as freedom together with contract as subjection, and then the immediate reaction looking for the way of limiting that content of subjection. A remedy for this mix, contract as freedom and contract as subjection, is putting limits to this content of subjection, limits to the autonomy of will. Therefore, and this is kind of a synthesis, the basic idea of labor law for me is this mix, contract as freedom plus contract as subjection plus limits to subjection. And that's universal, or almost universal, because then each one particular idea of labor law works that limit to subjection in its own way and normally in a different way. We'll see it later. So let me pose three schematic conclusions on this. This, as you see, nothing original, nothing new, but I think that it's expressive of what labor law is. The basic and historical idea of labor law is a mix. Use, please, this habit I have to repeat and repeat and repeat. That's 40 years. I've been a professor for 40 years, and that's what we do in class. We repeat and repeat and repeat to make sure that everyone follows us. It's the basic idea. It's composed by contract as freedom plus contract as subjection plus limits to subjection. That's all. Not more than that. It has to be so simple to be wide spread enough. If not, it's impossible. So, three schematic conclusions. First, labor law is a kind of arbitration or composition between those two aspects, contract as freedom and contract as subjection. Labor law implies an indiscernible mix of will and freedom together with dependence and subjection. And third conclusion, and sublimating, accept please me this sublimation, it could be said that through the debate by opposition of interests, the system labor law, the system of protection, implicitly looks for the ideal level of shared freedom. In fact, the labor debate is a debate looking for which is the ideal level of shared freedom, the freedom of the employer together with the freedom of the worker. And nobody, there's a solution for that, because, you know, of course, employer thinks that freedom is in some place very different from the place worker thinks freedom is. Even if it's like that, I don't agree with those who propose to abandon the idea, the contractual perspective, saying, accusing it of being formalist, excessively patrimonial, or considering it a false achievement. I'd rather say that a contract implies an incomplete access to the worker to his liberation, and it's about recognizing its insufficiency, about identifying the way of completing that perspective. So, in this basic historical conception of labor law, contract as freedom, contract as subjection or dependence, and limits to subjection, I'm one of those who think that anyway, contract is a valuable concept to understand labor law and which is compatible with the system of freedoms and the autonomy of the will. I think that without contract, we cannot even start at thinking in labor law as a space of freedom. Still, and I finished this first conclusion, in with the illusion of completing the definition of the basic and historical idea of labor law. What I have just described is what I consider the basic and historical idea of labor law, widespread everywhere, or almost everywhere. Let me postulate an elemental consideration on labor law and the principle of equality. So this is postulate. This is an apodictic concept that I think that helps to understanding that basic historical idea of labor law from William Part here in Italy, there in Latin American country, in Argentina, or even in any of the Anglo-Saxon countries where I've been discussing these ideas. Labor law is a law based in inequality as a pre-existent factual condition. It was, it was Sinsheimer who said, quoting Kant, that labor law is the final point of travel which started with workers as things. That's what we depart from, slavery and all that. Then it arrived to civil law, where workers is considered in a condition, in a doubtless condition of equality, and finally it's received in labor law in its condition of inequality. So inequality is a persistent factual condition of labor law. Second, equality in dignities as axiological counterpart. I think that that's the obvious axiological finalist sense of labor law. But I just say equality in dignities, because in the way of solving the problem is with the construction of balances and equilibria as an instrument to do that solution to this question of the inequality as persistent condition. What I'm saying is that in labor law, I don't find a way to material equality. I think it's impossible. I think that labor law does not assure equality, just in any case, equality in dignities as an axiological counterpart, but not equality in results it's impossible. Labor law cannot do that. The worker is the worker, the employer is the employer. They are not equal. They won't be equal no matter how many rights, how many possibilities the worker has. And besides, as you know, the legal regime intends to preserve the social situation, so it won't be changes of that condition. The most we can do through labor law is searching for balances, searching for equilibrium. Once I said all that, when I completed what for that meeting I posed as what I considered the stylized, the basic, the most elemental idea of labor law. May I repeat it once more? Contract as freedom, together with contract as subjection, together with ways of looking for limiting that component of subjection. The rest is what I would call the particular ideas of labor law. We start from the basic and historical idea, and then they come the particular ideas. The Italian law is a particular idea, Italian labor law. The Argentinian labor law is another particular idea, but I can do it in a more aggregate way. I can speak for legal systems. The Anglo-Saxon legal system is a particular idea. The continental system, in where you participate and we participate, is another particular idea of labor law. All of them, as it's implicit in the basic historical idea of labor law, all of them work limiting, trying to limit subjection. Notwithstanding, they use different sources and techniques. And it's just an example, very obvious. In the continental system, the one we share, it's mainly the law. For us, law is the main first legal experience, and also collective bargaining. But for the Anglo-Saxon system, they do this task of limited subjection, but they do it in a different way. Abstentionism of the legislator and the judge, even the judge, abstentionism of the legislator and even the judge, to give preeminence to voluntarism of unions, heavily regulated in the USA and the United States, unregulated in the United Kingdom. Third case, another legal experience, the German legal regime, in which is the law, as in our continental system, together with the dominant presence of the professional communities. So, what I mean is that after conceiving that particular and basic idea of labor law, shared almost universally, you have the particular ideas that do what that idea proposed, limiting subjection, but with different sub-sources and different techniques. Perhaps they share some features, but the Anglo-Saxon legal system share features with the continental system, even with the German system, but they are not a part of that very elemental idea, historical idea of labor law. And now, as we have works on a certain particular idea of labor law, we work on the continental idea of labor law. We stop with the widely and universal conception of law as an universal experience. We start working with a particular idea, and I propose to do it with our one, the one which we share, the continental legal regime. And there, the first concept, the first legal feature that I think it deserves to be considered is obviously the idea of dependence. It's obvious I'm not saying nothing original, not either here. Almost in a defining dimension, is frequently said that labor law is a system of rules applicable to dependent work. So dependence is a very important area. How labor dependence should be understood? From a technical perspective, I loved the expression of a young civilist legal scholar who works with Alain Supiot, and who said that dependence is a substitute of disposition. You know, it's not easy to separate. The work works from his work itself, and so as it's not possible as proper civil patrimonial relations to ensure the disposition of the object of the relation. The dependence works as a substitute of an impossible disposition. From a political point of view, dependence is that component of subjection. Dependence, our technical concept of dependence, is that component that in the basic historical idea of labor law we called the component of contact as subjection. That's what dependence is. And finally, from a descriptive point of view, dependence is just a way of working. It's that of the industrial worker in the first industrial revolution, whose main traits, whose main features are elevated through an inductive process to build a matrix or mold that constitute, and this is I think the most expressive idea, the conceptual and abstract replica of that way of working. What's dependence? The conceptual and abstract replica of a way of working which is the way of that industrial worker of the first industrial revolution. Then, as Massimo D'Antona said once, it comes the comparison case by case of each relation that we are examining with that mold, with that category. And then, after that, I think that I call that a judgment of similarity. A judgment of similarity case by case between the real relation we are considering and that mold that we have built, elevating inductively those main traits of that way of working. And then it comes the judgment of proximity. That's a political judgment when the relations do not fit exactly in the mold, in the matrix we have built. So we say, too next to fit, so it is. Too far from fitting, so it isn't. In a case it's dependent, in another case it's not dependent. In our law, in most of Latin American labor law, it's a thing of everything or nothing. If it fits, or if I say by the judgment of proximity, it's next enough, so it fits, we give him all the protection. If it does not fit, perfectly fit, and we think it's not dependent on the link, so we say it's not dependent, we don't give him anything at all. That's what, you know, the new experience is trying to solve through third categories, through intermediate categories. You know that perfectly well because you start with that, it's an obvious reference, that of the lavoro para subordinato, that intermediate category, but we don't have that. In any way, increasingly, labor laws, compare labor laws, are growing with that kind of third categories. It's obvious that the conceptual construction of that mold, I mean that conceptual and abstract replica of that way of working, means also anestheticization. And as it means anestheticization, it's that anestheticization which permitted the incorporation, the expansive process of labor law, and the consequent incorporation of other categories of workers. And then workers of the services, the agricultural workers, the civil servants, the domestic servants. All of that has been possible because we didn't work with the mold itself, with the person itself of the industrial worker. I always said we should have had an industrial worker on the table, and that's impossible. We worked on that stylized category, which is a mold built by making an abstraction, and that made possible that expansive process and this expansive situation of labor law, which includes most workers. Now, concept of dependence is in progress. You know that it's in discussion. Wherever it's in discussion. I remember that 30 years ago, I met him in Buenos Aires and in La Plata. A colleague of us, Marcello Pegazzoli, had written a book by then. I think his name was Lavoro subordinato ai dintorni può essere questo, lavoro subordinato ai dintorni. And there he expressed the illusion that the advancement of ideas would finish with dependency as subjection. Unfortunately, that didn't happen. Dependence is still there, but it's receiving a very extraordinary treatment in the Anglo-Saxon literature. Colleagues that deserve to be read, like Mark Friedman, Simon Deakin, are working on that, and thinking they can put aside the concept of dependence, putting together all the manifestations of personal work. Now, it seems to me that dependence is still alive in reality, and what is happening is that we are not able yet to rewrite it. We should rewrite it, and we don't know yet how to do that. In any case, let me call your attention on something that I call, and I think it's happening, called the subjective weakening of labor law, produced by convergent phenomena like informality, delaboralization. Do you know that word? Delaboralization. It's a neologism that means treating a dependent relation as if it weren't. That is delaboralization. We in Spanish say delaboralización. I don't know in Italian if it's a word that exists. But in any way, it's political, and it's the governments which brought delaboralización.
Delaboralización, but it's not so used.
So used. Well, we had in our countries delaboralizations. That means treating dependent workers, dependent relations as if they weren't. The vertical disintegration of companies, the preference for self-employment, that what Rodriguez Pinheiro called the flight from labor law. And finally, what the ILO has called the ambiguous relations, the most interesting manifestation that involves a gradual loss of representation of the dominant type of relations, what produces a kind of contraction of the personal scope of labor law. I think that contraction of the personal scope of labor law is happening, and that's what I call the subjective weakening of labor law, together with two more weakenings. We have the normative weakening, flexibility, deregulation, that means a normative weakening of labor law, and with the applicative weakening of labor law, the enforcement weakening of labor law, trying to produce a loss in the effectiveness of labor law. Labor dependence, as any other unequal relationship, is a relation of power. Power exists. Labor law recognizes it just to put it under his limitation techniques. And let me say, mainly for students, that power, together with freedom, are two main concepts of labor law who deserve each one of them by itself a deep study. Labor law is on power, labor law is on freedom. And I think that those fundamental concepts. So, what's a way of limiting that situation of subjection, which is one of the components of the labor contract? It's about redistributing powers. If dependence means power, what labor law has to do is to redistribute powers. As said before, so I am repeating now because I need it now, labor law is a law based in the inequality as persistent factual condition or presupposition, inequality in dignities as an axiological counterpart, and in the construction of balances and equilibria as an instrument to solve this kind of question. As I said, just looking for equilibria, not for equality, that it's not at the position of the techniques on labor law. That construction of equilibria is only possible by means of a redistribution of existing powers that each labor law, what I call each particular idea of labor law, makes in a different way. Now we are in the particular areas. We don't have that universality that we try to recognize in that basic concept, that universal, quasi-universal concept of labor law. In the individual labor relation, this distribution of powers is done by expropriating, by gaining power from the employer by means of norms that impose limits in certain labor conditions, and empowers of the employer itself as those of organizing, directing, imposing sanctions, changing some work conditions, all that. Technique nowadays enriched by the exaltation of the fundamental rights of the person, as of the worker as a person. So we have the traditional ways of expropriating power, and we have the new way, not that new, but the last, which is the recognition of the fundamental rights of the worker as a person in the workplace. In the collective labor relations, it goes in another way. It doesn't expropriate, doesn't deprive from power. It, on the contrary, it enhances power of unions. It promotes collective action. So it's a different technique. While in the individual relation, you take power, you deprive power to the employer. In the collective relation, instead of depriving, you add power. You add power recognizing unions and promoting collective action. And of course, there are also ways of redistributing powers in the procedural sphere by means of special procedures and special jurisdiction, and also in the administrative field by having the inspectorate, which punishes employers' transgressions. And it's very important to understand this. I'm thinking that for students, it's very important because if you think in the neoliberal project in Latin America, but I think it's similar here in Europe, what they proposed, and we had that in the 90s, and you have it now, right now here, it means a new redistribution of powers, deregulating for the individual relation, that means enhancing employers' power, and restrictive regulation on the collective matter, that means reducing unions' power. So, if you understand the way power is redistributed by labor law, you can understand why the neoliberal reformist process go exactly the contrary. And you can say that in Europe's happening kind of the same, and you find that flexibility and deregulation mean that redistributing power, in this case in favor of employer. I'm saying very obvious things, but obvious things that can be understood if you understand the way in which originally labor law works. If you understand that labor law works redistributing powers, depriving, expropriating power from the employer, you can easily understand what's the sense, the meaning of these kind of reforms. Perhaps I won't speak of that because each time that I speak of another regime on front of specialists from that origin, for example here, I'm always wrong, so I'll be very prudent in this. But I think that it's happening the same in Europe. And you have flexibility, which means reestablishing employer powers. And in this case, I think through the judicial action, the European Justice Court rules as Laval, Viking, Ruffert means restricting in a way, not saying that, but it means restricting collective power, restricting union power. Another feature I want to point, I want to mention, is that labor law, I think it's important, this labor law is a law under attack. Labor law is a law under fire. It means a lot. It's under attack in two fronts. Labor law is under attack in its theoretical legitimacy. It says it's interfering factor that disturbs the spontaneous adjustment of supply and offer in the market. It impedes flexibility, it impedes efficiency, it produces inequality between insiders and outsiders. So there's a questioning on its theoretical legitimacy. And this is a discussion I won't go in this moment because, you know, it deserves a seminar itself. But it's also attacked wherever, here and there, in its effectivity and efficacy. What we have called enforcement weakening. Remember, I think that we face three ways of weakening: the subjective weakening, the enforcement weakening, and the normative weakening, which is facing legal law. And it's attacked by means of the limitation of powers of the enforcement bodies. I mean, labor justice, labor inspectorate, and all the evasive strategies. And then, against that, and this is what I consider a very significant, a very important feature of labor law, there's an enormous apparatus of resistance which has centrality and richness of its tools. I didn't find in any other legal regime, in any other branch of law, such an enormous apparatus, an overwhelming and specific technology that cannot be found in other legal regimes, at least altogether as they are here. Just an example, just to mention it rapidly, the principle of reality and its effects, fraud and simulation. In labor law, fraud and simulation are people counter institutions. We studied them as institutions. And the techniques implemented to limit them, the anti-fraud techniques. The special warranties to ensure the access of workers to their rights. The imposition of diverse forms of passive solidarity between diverse counterparts of the worker. The imperative nature of the contractual type and the restriction to the free qualification of the labor ties. You know that, I think it's very important. You can't build a labor relation freely. Worker and employer talk and say you will work every day. No, I work once a week or twice a week, and I have a fixed working time. Not just you have you come when you want, you report, you don't report. You make that freely. But once you did that, have built relationship, you can qualify it. It is what it is. And if it's dependent, you have to accept that it's a dependent one. You are free for building the relation. You are not free for qualifying it. It's the law that qualifies that link. The nullity of transgressive acts, the presumptions and other mechanisms to facilitate the probatory activity of the worker. And obviously, outside the institutions, the standards themselves, you have the labor inspection and the union's controller action. What I mean is take a look at labor law. Labor law is a law who has an enormous apparatus of resistance against evasive behaviors. And it seems to me that it's a distinguished feature that defines continental labor law. Another one, another feature. Be quiet, I'm just finishing. And if I am not, I will anyway, not to lose you, not to lose my clients. That is an extorsive strategy, not to leave the classroom. The quantification of work, the quantification and the quantitative element. The quantification of work has been said by Alain Scipion. It's a strategy to have an abstract concept of law that can be the object of the exchange and commodification in the market. But there's another kind of quantification. Quantification was and still is a generalized technique of labor law aimed at facilitating access to workers' rights. So you have quantification in two senses. Quantification looking for an abstract concept of work that can be exchanged in the market. Quantification is a way of making easier the access to rights, to workers' rights. And that's very important. And it was my master, let me say 50 years ago, Mario De Viali, an Italian. My master in Argentina was an Italian-Argentinian, Mario De Viali, who spoke of the quantitative element of labor law, this way of facilitating access to rights, which has also, let me say, an ambivalent sense, because it's good for workers, because it eases the access, it facilitates the access to rights, but it permits the employer to predict its cost and to ensure its cost. So it's an ambivalent component, because it's good for workers, but it's necessary for employers as well. And now here I want to formulate a declaration, which is very obvious for all of you, but I think it's very important, and has been marked by the critical studies of law, which is functional, but I need to say it is the ambivalence of labor law. You know what we speak about when we speak about ambivalence of labor law. Do you? When we speak on ambivalence of labor law, we can take it from three different points of view. Labor law, at the same time that it has promoted workers' protection, it has been useful to legitimate the market economy in its competition with real socialism. And it's true, it worked like that. And the problem we have now, and it's a huge problem, which is can be seen in ILO, is that when the real socialism has fallen down, there's no more competition, and that ambivalence loses its space. And employers and defendants of the market economy don't need anymore to support labor law to be able to compete with the socialist reality. And that's what's happening now. And Giuseppe, that fight against the right to strike, and this fight against the organs of control in ILO is just an expression of this loss of ambivalence. Employers are very strong now. They say we don't need more conventions. A friend of mine who was, a very old officer in ILO says In the ILO, it's easier now to get a declaration that the convention. Employers won't sign any convention. They sign that of domestic workers because it does not affect the capitalist logic, but anything else is possible. Why? Because that ambivalence in which converge conception of progress together with conceptions of conservation has lost its space because of the fall of the real social groups. We have problem there. But there's a second space of ambivalence of labor law. Labor law seeks to emancipate, and at the same time it contains limits. It offers liberation from needs to the worker, but impose in its place, we have taken the same ideas we started with in a different sense. It offers liberation from needs, but impose in its place subjection under the form of dependence. It offers a voice to workers through unions, but it tries to put unions within the limits of the legal regime. At the same time, it offers liberation and it puts restrictions. And finally, it's also a manifestation of ambivalence. That's what we said about the quantitative element. The quantitative element is good for workers because it permits the access to rights, but at the same time, it permits employers the predictability and the insurability of their obligations. In any case, I would say that that bias of ambivalence, which in my opinion is so important, should be continuous studying because it means a lot for labor law and what is happening in labor law. The entrance door in each of those cases is protection. It's true that the function of legitimating economy, warranting flexibility, ensuring predictability and insurability are accessory functions. There's a recent work of an Israeli, Louis Davidoff, has treated especially the main functions and the accessory functions of the labor law. It's very interesting to see that. The last of the features I want to consider in this opportunity, just to let you alive, that's some reason to stop here, is the obvious peculiarity of the system of first sources. A particular idea of labor law, it is how it is, depending on how it distributes its contents among law, collective agreements, and individual contracts. Any particular idea of labor law may be described according to the way it distributes contents between law, collective agreements, and individual contracts. And that's obvious. And if you take a look at the tensions of reform, you'll see that that's that way. What's flexibility, in fact? Flexibility is a constant pressure to suppress contents from the law in order to transfer them to a space of the collective autonomy, and in its deepest cases, to suppress contents of the law and of the collective agreements to return them to the individual contract. That's flexibility. Flexibility is a question of sources. It's a question of that way of being of labor law, depending on the way it distributes its contents among law, collective agreements, and individual contracts. And finally, I say that if you want to give a very rapid description of the system of sources, you could say that the system of sources is, before all, a system of limitations of the autonomy of will. If you compare it with the system of sources of civil law, you will find that in the system of sources of civil law, you have the contract in the middle, in the center, the contract is the king, and then you have law around it. In labor law, it's different. In labor law, you have contract, but you have mainly a system of limitations of autonomy of will, in which law limits collective agreements and law description of the system of sources through 5 variables, but I won't say that because I feel that my time is over. I should stop. Let's just finish saying that this effort to find out which are the defining features of the law is useful in this very moment, because if you have changes in those defining features, it means that the labor law is changing in a deeper way. And besides, finally, I found that these defining features are, as Scipio said, clés d'intelligibilité that permit to better understand labor law. A law in which there's that universal idea, basic idea, historical idea, in which there are particular ideas with different techniques and sources, in which you have distribution, redistribution of powers, in which you have the quantitative quantification of rights, where you have the right under attack. Those are features that, in my opinion, are the most important in the description of the current labor law. I'm not sure if there are some others. I'm not sure either if each one of these, which I mentioned, are really defining features. I'm just posing this in this essay as an hypothesis to try to discuss it and to understand it. Thank you very much. Those are my friends.